this is Brian Jackson from Lawed Up. The whole purpose of this Lawed Up podcast is to help everyone understand the law a little bit better, even if you haven't been to law school or not. So today we've got an interesting topic, and that is on Blake Anderson. So he was a prior USU coach, Utah State University football coach, who has been terminated. And yesterday, a lot of national news got his attention, and I did a lot of research on it. I wasn't familiar with this case at all until yesterday. So there's a lot of stuff I still don't know, but want people to be informed a little bit about the process as it relates to terminating a government employee, and specifically here as it relates to possible Title IX issues. And so I researched this a bunch. Hopefully you'll be able to understand a little bit more about the process and this current Utah State situation as well. So my understanding is that Blake Anderson in July of this year, 2024, received a notice from the university saying that they were going to terminate him. So just so you know, public employees have due process rights. And a lot of people don't know that. I have a lot of clients that call me, even government employees, which is crazy because they should understand their rights. And because where I am, it's an at-will state, and so they say, oh, well, it's at-will, so they can terminate me for whatever reason, and I'm out. And as a government employee, that's generally across the board not true. There's a reason for that. So in the Constitution, we're talking about Amendment 14 of the Constitution. It says that no state can deprive an individual of life, liberty, property without due process of law. So what that means is that you have to have some kind of process due to you before they can deprive something of it. So process means like some kind of judicial adversarial proceeding, some just and fair proceeding, some transparency where both sides are able to present evidence, call witnesses, cross-examine witnesses, stuff like that. So you should be able to do that before you get deprived so for example, that's the whole reason why we have criminal procedure, is that you can't be deprived of your liberty. And then also Fourth Amendment rights, you can't be deprived of your Fourth Amendment rights without due process of law. So that's where the process is due, essentially. So what the general law is if you're a public employee, then you have a property or liberty interest to your job. So what that means is that you can't have your job deprived of you unless you have some kind of due process. And that's on the state level. Same applies on the federal level, essentially, but we're just specifically talking about state employees. So there's two hearings, essentially, that you have to have. You have to have a pre-termination hearing, which is kind of like a mini informal hearing where they give you notice of the charges, of the evidence, of the witnesses, and you kind of usually meet up in an informal setting, and you're able to respond and say, hey, no, this is not what happened, or whatever, and give your side of the story. And then at that point, and that is just a pre-termination. So what they're supposed to do is say, hey, we're thinking about terminating you. So this is the reason why we're terminating you. We're going to give you a chance to have your say prior to that. And then typically what has to happen is they can come out and they can make a decision. If they say after the pre-termination hearing, we've decided to terminate you still, then they can come out with a decision to say, we're terminating you, and then at that point you have the right to a hearing, full-on, more formal hearing where there's typically some neutral decision makers like a board or panel of people, and there you're able to present evidence, you're able to call witnesses, you're able to cross-examine witnesses. It's a little more formal than the pre-termination hearing, and sometimes some states, they even have administrative law judges come in who are more neutral, not attached to the situation, come and hear the evidence, listen, and then come out with a decision. And so you have the right, if you're a government employee, to go through that entire process before they can terminate you. They just can't come up to you and say, hey, you're terminated. And if they do that, then you could say, hey, my due process rights were violated. You guys didn't follow the procedures in terminating me, and you could have like a civil rights due process claim as a public employee. So that's kind of the background. And so what's going on here with Blake Anderson, obviously he's a public employee, he's a football coach. And so he has rights to that as well. It's a little bit crazy too with universities, because universities have their own internal policies. And with all of these pre-termination hearings, you have to follow the government entity that you work for, whether or not it be a city or a county or university. You have to follow their procedures, and sometimes those procedures don't even add up to what you're required, what you're allowed to have under due process. So you're allowed that pre-termination hearing, and that termination hearing, and if something is wrong with their procedure where you're not allowed to cross-examine witnesses or call witnesses, or they didn't allow you to use certain evidence, and their policies don't allow that, that could also be a claim saying, hey, we were deprived of this. So background on Blake Anderson now. So Blake Anderson, and this is, I guess we even need to go farther back. And this is what I found out too, and the Utah State University settled a case of a female who alleged sexual misconduct of a football player, and so Utah State and the Department of Justice, so the Federal Department of Justice, actually did an investigation too and said, hey, we're seeing issues here with your policies and training and what you guys are doing when sexual harassment is reported, stuff like that. So I assume what happened is they got a huge fines from the Department of Justice, and the Justice Department probably entered some kind of settlement agreement with Utah State University saying, you have to do this, you have to get your policies and procedures up to speed, you need to do this, you need to do this, a bunch of hoops that Utah State University has to jump through. So the settlement, I don't know when the DOJ settlement, I mean, there was a settlement with the female, but then I assume there was also this agreement with the DOJ. And I don't know if that happened before or after the settlement with the female, but that happened in October of 2022. And so then you fast forward a little bit more into early spring 2023, and apparently, according to Utah State's website, there was a female who was, and it doesn't specifically say, it just mentions sexual misconduct and domestic violence. So it's maybe something along the grounds of domestic violence and some kind of sexual misconduct. There's really no factual details as to those incidents that I'm aware of. So that allegedly happened back in 2023, and I don't know what happened at that point. I don't know if the female had got an attorney and wrote a letter to Utah State University and said, hey, we have concerns about this situation. We think that there were some people who talked to us and it wasn't properly resolved. That's kind of the background. And so now you need to understand too, complicated stuff, is the university's requirements when it comes to sexual harassment. So you have Title IX. And the Title IX, it's federal law, and it's pretty much like, it's a weird law, and it's weird how it's written by the Congress. but it's kind of like a contract with universities because the the Congress gives federal funding to universities, public and private, including loans to their students. So all universities are essentially getting public funding. And so because of that, like the contract, it's saying that if you enter into this contract, you have to make sure that your university is free and clear of discrimination based off sex. And so that's kind of the issue. The DOJ could come in and say, hey, you breached the contract, and then there could be sanctions for breaching the contract. And I mean, worst case scenario, they could say, hey, we're pulling funding, and that pretty much could kill a university. So universities are pretty much at the mercy of the federal government under this contract. And also, so under Title IX, so because of that, a university can be held liable if they breach that contract by a third party, so like one of their students. So their students are kind of like a beneficiary to this contract. And so that's where these Title IX lawsuits come up. But the other thing is it's always hard to sue the government. It's never easy to sue the government. And so you have to prove that a person that had the power to change the situation knew about the misconduct and did nothing about it. So if there was sexual harassment, student on student, and the university wasn't aware about it, the university probably isn't liable. Or if there was sexual harassment and a janitor saw it but didn't report it, they still, or knew about it, still may not be liable. And so what universities do a lot because of that to try and avoid liability is they try and it's up to them to create their own policies on who is going to make changes. And so a lot of universities make it so there's just a few people can make these changes to make them less liable, because then they can claim, oh, well, our decision maker didn't know about it, so we couldn't be liable. But that can create other liabilities just because their policy is so small and a bunch of people are knowing about it anyway and they're not doing anything about it, could still get them in trouble. So typically, university should have a good balance where it's not too small but also not too big where the janitor could potentially get in trouble. Just, if I was an attorney for a university, to protect the university, I wouldn't want to have a policy that says if anyone knows about sexual harassment, they can change it. But also, just a practical matter, there are just only some people that can technically change it. So that's kind of what you have to prove. It's a very high burden. They're very hard lawsuits, and they've actually even got harder lately because the Supreme Court just came out just a few years ago. In the past, these were pretty lucrative, good cases for attorneys to live off, because you're talking about sexual assault, sexual harassment stuff, and so you can recover, in the past, emotional pain and suffering and medical expenses past and future, which are the main damages essentially that makes the case pretty substantial. But the U.S. Supreme Court just a few years ago just came out and said that you can't get the emotional pain and suffering generally and the medical generally because it's a contract. And in a contract, you can only get damages for a breach in contract. And so typically, a breach of contract, you just get the money that you're owed under the contract. So the main damages would be if the school discriminated against you and deprived you of your education. I guess you could technically try and ask for your tuition back. And that's pretty much could be the main damage. Maybe you could prove that because of the breach of contract, it affected your career and your ability to get a degree. If you didn't graduate, that could be a substantial damage. But those are harder to prove because the more speculative the damages are, the harder a judge would say, yes, that's part of the breach of the contract. So the U.S. Supreme Court really took the wind out of the sails of Title IX cases, and so they aren't as lucrative, and really takes a target off universities' backs, really, because of that. But despite that, back to Utah State. I mean, Utah State, I assume, still has this DOJ agreement saying, hey, you've got to jump through these hoops because of this situation from this investigation. So Utah State is on high alert. And for whatever reason, there was this incident, like I mentioned, in 2023, in the spring of 2023. And for whatever reason, I don't know why, it could be because of this DOJ situation, plus could be the girl that alleged sexual assault had an attorney or just reached out to the university and said, hey, this happened and these people knew about it. And so what Utah State did is they got an independent investigator, a law firm, and they investigated that sexual assault or sexual misconduct, not sure what it is, domestic violence situation, and they named a couple individuals that knew about it and didn't report it. And so apparently under Utah State's policies is you have to report it to the Equal Opportunity Office. All sexual misconduct has to be reported to the Equal Opportunity Office. And that could have been that wasn't the policy before, and they had to make that new policy because of the DOJ. I mean, I don't know. And so they could have conducted that investigation, and it probably was to watch their back and make sure that they weren't held liable for this person, and if they were, that they could try and mitigate that liability and take any measures necessary at that point to fix the situation, to say that, hey, look, we fixed it and we got rid of the problem. And so it seems like Blake Anderson and some other athletic directors knew about the situation in February 2023, and it appears, and this, I don't know, I mean, this is all based really mainly off Utah State's website, which is bizarre too, on how Utah State is kind of reporting on this. If I was them, I wouldn't say a thing about this. So it is bizarre, some of the stuff that they're coming out with. And I think they're snippets from the Utah State newspaper, but still bizarre that they're posting it on their website, especially, some of them talking about the process that they had with Blake Anderson. So anyways, so they decided that, so they looked at it and they said, well, it seems like they knew about it and they didn't report it to the EEO office. And you're supposed to report it to the EEO office. And I don't know what happened behind the scenes. I have no idea. I don't know if they tried to fix it themselves and just said, okay. Or another thing too is a big question is, okay, well, how much can a university, where's their power, where's their jurisdiction? Is it just on campus? Is it just off campus? And a good university attorney would want to limit the jurisdiction as much as possible. Like, we're not liable for sexual misconduct that occurred, off campus by two individuals. But some universities have policies that can extend that far, saying if you find sexual misconduct of a student, even if it's off campus, you have to report that. And I mean, that can be good practice because, I mean, even though it may be off campus, that could still be tied to a bigger on-campus issue. So either way, I mean, I guess there's pros and cons to limiting it or making it bigger. But I think one of the issues here is they're saying, well, why is the university even involved? Like, this was an incident that occurred off campus. From what I've been reading, I think one of the responses is saying, well, you don't even have jurisdiction over this. But it could be based off the university's policy. So if the policy says that you have to report any misconduct from any student anywhere, whether it be on campus or not. And 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 obviously there's got to be off-campus situations, especially in sports, where you have players that are um, traveling elsewhere, and an incident happens um, while off to a sport. I mean, that could still be within the university's jurisdiction. So, anyways, so I guess they're saying that, okay, you guys didn't report this, and you should have, and so now we are firing you. So that's kind of what happened in a nutshell, generally, and now you have all the legal background understood as well. So, um, because of that, I think there was that pre-termination notice that was given to um, Blake Anderson, and I think he responded with an attorney with a 72-page response. He posted some of the responses on Twitter, but there wasn't really anything substantive. And obviously, it's a touchy issue. It's involving a victim of sexual assault, so there's a lot of stuff that they should not be making public. So there isn't a lot known about the situation. And so what I assume is he just said, well, a good attorney is going to come up with whatever reason to say I'm not liable. And then on the Utah State website, they're saying, well, we weren't satisfied with his response, and he was dodgy, and he didn't admit fault. And so it kind of sound like we wanted him to fall on the sword, kind of thing. And so that's why we terminated him. And so that's what happened, is University of Utah terminated him. But I guess from the university standpoint, I've only digested this in a day. I have no idea what's going on at Utah State University, but I assume with the past DOJ issue and potentially with this victim coming forward too, that they were under a lot of heat, and that the actions of Blake Anderson could have been a violation of potential DOJ agreement that made, and even a possible settlement agreement that they made with the prior victim in 2022, because sometimes settlement agreements have something that says that you're going to change your policies and you're going to conduct training and everything, and so if that happens, that could be a breach of the settlement agreement of this other victim too. So Utah State was probably under a lot of pressure with all the heat they were getting beforehand, and this is why it came to where it was. And why they were so stringent, because there was a lot of on the line for them, because potentially DOJ could say, well, you guys messed up again, we're going to pull your public funding. So that's probably why things escalated as quickly as they could, and they were walking more on eggshells than they did. And yeah, I mean, the concern, coming from the victim, if just the football coach steps in to address it, and maybe a couple other athletic directors, the university doesn't come in and address it, and they don't address it properly. Maybe they have a little bit bias. I don't know who the player was. I don't know the circumstances, but if they were just trying to downplay it to save the football player, instead of address the seriousness of the situation, that could be a big issue. And so that's kind of where we are. And so now we fast forward to yesterday, where Blake Anderson's attorneys issued a statement, and he posted on Twitter, and that's why it has gotten all this national attention, was his tweet, or X tweet, whatever it was. And so they are saying, well, and they made it sound like, well, there's this smear campaign and misstatement of facts and everything, and he's innocent and he did everything correctly. So that's what it'll come down to. And they're saying that they're going to file a lawsuit for wrongful termination, but again, going back to the very beginning, it's not your typical wrongful termination. It's a due process claim, that if they do it correctly unless they claim that they discriminated against him based off his gender for whatever reason. I don't know if that's a potential claim, but the main claim is my due process rights weren't afforded me, and that's a hard case actually. That's really hard to prove if he was afforded the right to respond, and if he was afforded the right to all the evidence, and he was afforded the right to call witnesses and cross-examine witnesses, and then they came out with a decision to terminate him. That's hard to come to a judge and say I wasn't afforded due process when he was actually afforded due process. I mean, I did look at Utah State's policies, and it is a little bit weird where it says that you can grieve a termination decision and say that, if there was a policy violation, you can grieve that, which to me is weird because, I mean, you're entitled to that termination hearing, and it should just be a hearing on the facts and not just, oh, well, you violated policy in doing this. That's kind of like an appeal after the termination hearing. So there could be an issue with Utah State's policies in the termination hearing, where you can only talk about, their issues with the investigation prior, instead of just looking at the facts like a normal trial in the law and saying, okay, yes, we think you violated policy, instead of saying, well, Utah State messed up. They violated policy in deciding to terminate me. So there could be a legal issue there. But one question too is, because it doesn't sound like, because typically if you're a government employee, you have the right to appeal a decision. And if you've made the final appeal in your city or county or university, the next step is to, depending on the type of hearing, is to appeal. And this is just in the state of Utah, at least. Other states might have a different procedure, but you make an appeal to Utah Court of Appeals, or you make an appeal to a trial court if it's a informal hearing. But it sounds like it was a formal hearing, so the appeal would have gone to the Utah Court of Appeals. And it doesn't sound like that has happened. And so there could be an issue with him not even jumping through all the hoops before he can file this civil rights claim. So the university, if they filed a lawsuit saying my due process rights were violated, Utah State University could say, well, you didn't file an appeal. And I don't know if just having that termination hearing is sufficient to say that I did enough, or if he had to appeal to the Utah Court of Appeals. Maybe it could be that he could have done enough. But yeah, in my mind, when it's all said and done, with everything I just told you, it seems like, without knowing the facts and just generally speaking on how these types of claims work, it's an uphill battle. And these types of claims are hard to prove. It's going to be hard to prove that Utah State messed up procedurally and he didn't get the due process he needed. So, I mean, and maybe that's why it's getting the national attention it is, to try and put more pressure on Utah State. I don't know. And I don't know what his contract says too. I assume that they're claiming that because you were terminated for cause, that you don't get the rest of the money under the contract. And so I think that's the big fight, is he just wants the remaining amount under his contract. And I'm sure that Utah State will probably come to some kind of resolution with him and figuring out how much he should be paid out under the remainder of his contract. But so that's pretty much a very complicated legal scenario. These employment cases can be very complicated. You got to be a very sharp attorney in dealing with these cases, because you're dealing with university policies and laws, you're dealing with federal laws and policies, you're dealing with state laws and policies and procedures. And so you really have to know where to go next, what your client's rights are, what you need to prove, what your burden of proof is, and everything like that. And so, yeah, so that's it in a nutshell. um, government termination procedure. So now you know that if you're a government employee, there's a lot of rights you have before being terminated. So make sure that your due process rights are fulfilled before you get terminated as a government employee.